Good morning, good afternoon, and good evening. Welcome everyone to this week's Law Science event. Welcome also to those who will rewatch this session later. I'm Simon Sun, an SGD candidate at Merit School of Law and the moderator of this session. Before turning into today's speaker, Fabrizio Esposito, let me briefly introduce the Law Science Project. Law Science is an academic initiative coordinated by a group of SJD candidates who share the same belief in legal methodologies, often understood as a discipline distinct from science, traditionally consisting of doctrinal analysis and normative questions. Through the series of interdisciplinary talks, we aim to show that legal research can be improved by and benefit from scientific methodologies that provide systematic ways to approach questions. If you want to learn more about the Law Science Project, please visit our website and join our email list. I will share that in the chat later. And this is actually a pretty good point to introduce our coordinators who unfortunately cannot join us today, but they all helped to craft the agenda for this semester. So besides me, we have Daniel Hefke, who is an SJD candidate at Cornell Law at Maryland Hodge, an SJD candidate from University of Virginia School of Law. And also we have Vanessa Villanueva, who is a former coordinator and currently a senior fellow and the chief editor of our legal method lab at Law Science. We also have representatives at diverse law schools in the United States, such as Berkeley, UPenn, University of Illinois, Georgetown, University of Washington, Columbia, and Fordham. This session was promoted in all of these law schools. If you're interested in getting involved, we're always looking for new law science representatives. We also host a blog on legal methodology, the Legal Method Lab, for which we're currently searching for editors. So if you're interested in becoming either a representative or an editor, please reach out to us. So let's turn into our speaker today. Professor Fabrizio Esposito is an assistant professor of private law at the Nova School of Law in Lisbon and holds a PhD from the European University Institute. We're very fortunate to have him joining us today. His research focuses on exchange contracts that he argues are best understood in terms of consumer welfare maximization and consumer sovereignty, so that the legal system complements and substitutes the invisible hand in putting consumers in the driver's seat of the economy. This perspective is developed in particular in his book, The Consumer Welfare Hypothesis in Law and Economics. Fabrizio has published extensively on the methodology of law and economics with a focus on consumer law. He has co-edited research methods in consumer law, economics, and legal reasoning, and the Cambridge Handbook of Algorithmic Price Personalization and the Law. This session today is about the consumer welfare hypothesis as legal science, searching for economic concepts that fit with legal discourse. We'll have time for a Q&A at the very end, so please prepare questions. The event will be recorded and uploaded to our YouTube channel, so you can either raise your hand or write down your questions in the chat box, and I'll read them for you. But now, without further ado, thank you very much for joining us, and the floor is yours, Professor.
So thank you very much, Simon, for the kind words, but please don't call me professor again in this context or in another one. I would appreciate that. I thank you everyone for being here, especially understand that lunchtime on the day after Halloween could be pretty challenging one. So I appreciate that. I'm gonna share the presentation now, and before I forget, since I will mention this point again, but one of the pop culture images that I use in the book to make sense of the reality that I have been dealing with in my research is that of zombies and necromancers. And since, yes, it was Halloween, it was specifically makes sense to mention that specifically. Now, I feel like Simon has already said everything that is really important to say. So I will try to be as quick as possible and develop on that. And I will try also to be provocative here and there so that we can perhaps some discussion today or in the future. If you have the time while I'm talking, you may want to go through these 8 questions that you can find on this website. You just need to write down that code 31 29 50 04, and you can answer some questions that I think are useful for brainstorming purposes with regard to the content of the talk. I do not know if I leave it entirely to Simon to decide whether we should give the audience 2 minutes to do that, or I should move on, because I have the questions and I will tell you briefly what my answer to this question is, but I think it might make.
Let me share the link in the chat, and then people can fill it out while you are speaking. Is that okay?
Yeah.
The code, can you go back to the code again?
Ooh. It's here. Oh, can you see it?
Yes. Okay. Okay. Perfect. So please make sure to log in and use the code. And I think you can proceed, Fabrizio.
Right.
Yeah, people should see the link in the chat.
Okay, so let me jump to the next slide so that I do not completely spoil the content of that one. So this is the hypothesis that I have been working on, and it is an hypothesis that is meant to be distinctively narrow in scope, and to be distinctively humble in the content of the claim, because I'm not in this version of the claim is not that this is the best way to understand the real normative foundations of the EU legal order, in particular antitrust and competition. No, I'm simply claiming that it is easier to understand that structure in economic terms if we use one definition of allocative efficiency that is different from the definition that you normally learn, right? So part of the challenge was to justify these alternative as existing. Now, in later work, I have been because I think it is actually the position is stronger than the way articulated in the book. I have been working on providing the reasons why I think that this is the case, and I will touch upon those as well. So this is the cover of the book with the nice things that, among other people, Annalise Siboni, who is in the audience, buon pomeriggio, has said about the book. And in a nutshell, I think that this is the end goal of a book like this is to change the way in which we think about certain issues. And this is not only an exercise in clear thinking. I think it also creates the cognitive space, which probably is 5 years ago, I would have said, is more important in Europe than in the US, but maybe now the situation is more homogeneous. It creates the space for not considering economic analysis necessarily an enemy, which is not. It is the case that for certain type of agendas, if you historically look at the way in which it has been used by people engaging with legal scholarship, you may say that it tended to swing more in one direction in comparison to the other. But this is an analytical framework, and being an analytical framework under the right under the right conditions, it can be used to investigate the plausibility of any normative position. And for example, it's very interesting that this book by Paolo Siciliani, Christine Riefa, and Harriet Gamper, it does a very nice job in that regard, but they move from the unjustified assumption. They simply state at one point, around page 4 or 5, that they will understand fairness in consumer markets as consumer welfare maximization. And then they just deliver results because they are capable of saying very interesting things without justifying that assumption that for many people could be seen as surprising, perhaps. So in a way, what I tried to do was provide the conceptual foundations for a claim like that. So why is it the case that it makes sense to provide to move from that assumption? Because there are reasons that suggest that that's the case. And why I think this is a particularly important perspective. I think it's a particularly important perspective because not many people have worked systematically with this idea in these areas. So the normative tends to have a lot of space very soon, to the detriment of the clarity of the analysis. But if, as all of you have been reflecting on law as a science, you will sooner or later, you will have come across, you will have realized something along these lines. Whatever descriptive analytical claim I find to be justified can then be connected with any normative position whatsoever that I want to justify, right? So if you find that markets are particularly competitive and you want to push a conservative agenda, you can use that information. If you find that the law, or better yet, that the law assumes that markets are particularly competitive, you can use that for certain purposes. But if you instead believe that from an empirical point of view, that assumption is incorrect, you can use it for other purposes, right? Then you can engage in some critical engagement with the relevant legal materials. And I found that both in legal scholarship, in the law and economics tradition, and also on the Great Lakes, there were people that were strongly and stubbornly, perhaps, or still are, defending this view, both in law and economics and in economic analysis, in a context where this seems to me not to be the case. And in particular, Warren Samuels has this very, very nice expression that he uses in more than one paper when he talks about this idea of the legal economic nexus. So the idea that legal structure and almost a Marxist idea, their legal structures and economic structure are necessarily intertwined with each other, and we cannot properly understand one without trying to properly understand the other at the same time. He keeps writing, and this is true, whether you like it or not. This is the whole point. The point is that whatever we find with a proper commitment to the truth remains true whether we like it or not. And then if we like it, we're going to have a certain attitude. If we don't like it, we're going to have a different attitude. But at least we owe it to the kind of position that we hold in society to tell it like it is when, or at least to tell it like we think it is. So this is the main point. What I want to make clear before going further is that there are some clarifications that I have learned over time that is useful to make early on. If I went through the slide where I give you my answer, more or less you would get the same idea. So the first very important idea is that I am not assuming in any way that real markets are normally competitive, even in those situations, which are a lot, where the evidence suggests that this is not true, right? In my understanding of neoliberalism, that is the quintessential neoliberalist move. I do not need to engage you at the value level if I believe that if I can push a story about how the real markets that we have are going to deliver all sorts of wonders. I just win it at the institutional level without having to engage you at the normative level. This is not what I am talking about. I am also not talking about the idea that the only thing that we should care about in society is consumer welfare, right? So what I am talking about is the idea that in a certain type of contractual interaction, which I call exchange, and I oppose to organizational contracts. In exchange contracts, it is the case that this goal has a lot of explanatory power with regard to the legal institutions that we have and the development that they have over time. So this is my claim. And this claim does not entail that values that are conflicting with the values that are internal to those of that institutional practice do not matter, right? So there is no contradiction between saying that exchange contracts should maximize consumer welfare and claiming that certain consumer options should be eliminated because they are environmentally or socially unsustainable. What we would observe, if my claim is correct, is that the kind of legal basis that we need or that judges normally rely upon in order to make one claim or to make the other will be different. So if you are restricting consumer, or also the legislator, if you are restricting consumer choices for environmental purposes, these will normally require to invoke certain legal bases for that that are different from the legal basis that you normally use to adjudicate conflicts between consumers and traders. And the last point, which has a lot of theoretical implications, I think, is that in my understanding, the economic framework that is most beneficial for talking about exchange contracts is that of a principal agent model, where the consumer, or more generally, the creditor or the characteristic performance is qualified as the principal, and his counterparty is qualified as the agent, right? So, for example, for me, I struggle a lot as a non-US scholar to build a sharp distinction between contracts and fiduciary relations in this regard. Because for me, at the normative level, the agent operates on the market, operates as a fiduciary of the principal, and then the only reason, and this would need to be investigated further, that can justify more or less space for fiduciary-like duties in contractual relationships has to do with the institutional settings that are contingent to that particular interaction. So why did we got to this situation where you also felt the need, right, to have more, to give more space to the descriptive and try to avoid normative conflicts between legal analysis and economic analysis of certain issues. This is where the zombies come in. So I am a bit reluctant to say this in front of Professor Mercuro, but I think that this is true, so I have to stick to it. What I found is that, for example, in chapter 2 of the book, I analyze what several economists that I believe are arguably fundamental for the development and the conceptual and historical development of the law and economics movement said about the conflict between consumers and traders on the market, right? So to what extent there was a distinctive concern in their work for the distributive effect that a certain market conduct, and in particular monopoly, would have. And the most interesting thing that, one very interesting thing that I found is that Adam Smith provides the boldest quote ever in favor of the idea of consumer welfare as the maximum of allocative efficiency. But the other thing that I found that is very important is that both Kaldor and Hicks of the very complicated Kaldor-Hick efficiency, right, where you can take entitlements away, provided that theoretically you could compensate the party that you're taking the entitlement from. Especially in Hicks' work, Hicks uses that kind of test to tell you, well, this monopoly problem, we cannot really solve it by taxing monopoly profits away. Because even if we were to perfectly tax monopoly profits away and transfer them to consumers, consumers will still be worse off. So in the alternative between perfect competition and monopoly plus perfect taxation, consumers are still better off in perfect competition. And this is a very different use of that test in comparison to the one that we have all learned is the proper way of using that test. The other problem that I think is very significant in this context is a problem of reification. So we tend to assume that if some people talk about efficiency, they need to mean something different from what other people refer to when they talk about fairness. But I just showed you the book by Siciliani and others, and they move essentially beyond that, and they deliver very nice results. But if you actually look at the way in which the European legislator, not academics, not courts, but the European legislator talks about efficiency and fairness in very crucial moments of the structure of the internal, in very crucial points of the structure of the internal market, they use the two expressions interchangeably or within a conceptual framework that clearly makes sense of their relationship, not as alternatives. And the most important idea that I have to deliver to you in this regard is that even if you do not accept the consumer welfare hypothesis, it is still true. So if you accept that efficiency has to do with total welfare, there is still a clear equality norm that supports that idea. So, and this is important because if the idea that the market should maximize total welfare is justified by an equality norm, and it is true that equality is the quintessential stepping stone for a theory of fairness, then assuming that efficiency and fairness are necessarily conflicting concepts is just the recipe for reification. Because the equality norm that total welfareists rely upon is the idea that the state has no reason to prefer the interest of the consumers to the interest of the traders on that particular market. So the reason for preferring perfect competition to monopoly is that in monopoly, there is less available for everyone, independently of who loses that. And that is the famous triangle of the deadweight loss that you can see also on the cover of my book. But the alternative efficient equality norm that supports the idea of the consumer welfare hypothesis is the idea that everyone, so this is where the equality element kicks in, everyone, when is operating on the market in the capacity of consumer, is sovereign. And the same person, when he or she is acting as trader on another market, he is the subject of the consumers on that market. So, and in this sense, we are all equal in a market economy. We're not equal in the relationship in the sense that our interest matters equally, or that we should split the benefits, the surplus from the transaction equally. We are equal because we accept equal roles in society, okay? And this is at the core of the idea of consumer welfare, of consumer sovereignty, in the richer understanding that I reconstructed in chapter 2 of the book. And that's why you have a crown on the cover of the book. And the reason why the crown is heavier on the scale is because in the second part of the book, I develop a methodology that is what I'm going to talk about next, to check which notion of efficiency, as Calabresi and Warrens recommend us to do, which notion of efficiency fits better with the way in which lawyers reason when they reason about EU antitrust and consumer law. So the scale on the cover means two things at the same time. First, that we are talking about justice, at least in the sense of the institutionalized idea of justice, so the justice system. And secondly, we have the idea of the evidence represented as something that is weightier on one side in comparison to the other, right? So already in the cover, there is a commitment to the descriptive nature of this project. Here, in the text that was circulated, these are the kind of uses that are more critical that you or are argumentatively more significant of what you can do with this account. And this one operates as a shield, right? So you say, oh, if somebody tells you, oh, this norm is bad because it is inefficient in the total welfare sense, you say, oh, but in my legal system, the efficiency I care about is consumer welfare, goodbye. Or you can actually engage with that person on its own terms and say, oh, you know what? I accept that this is about efficiency, but in my legal system, efficiency is about consumer welfare, right? So I rely more on a certain economic tradition that you do not rely upon. And when that happens, guess what? The norms that you're criticizing actually make sense to me. So you do not use it as a mere shield, but you actually deflect and counterattack on the same terms of that person. And so this is the structure of the plan. So of course, in part, in chapter 1, I discuss all the many negative sides of the state of the art the way I see it. And the main point is that we lose a lot of time in debates that rely on an assumption that is problematic in and of itself, without considering that an alternative assumption exists, and that assumption is that allocative efficiency is about consumer welfare, right? And I document how this is problematic at the theoretical level in debates about antitrust law and debates about consumer law. And then part 2 is dedicated to create to put in the people's brain the doubt that allocative efficiency can be actually defined in consumer welfare terms. And as you can see, there are these green buttons here. If you want to know more, I can tell you more. But the bottom line is that I rely on strong conceptual reason and on the view of economists whose work has been central to the law and economics movement, including, as I said, Kaldor and Hicks, but also Ronald Coase and others. In the second part is where it gets interesting, because that's where I think I have an original way to connect doctrinal analysis and economic theory. And the idea is essentially that of trying to perform what I find the most important contribution of Richard Posner's at the methodological level, the idea of an efficiency hypothesis of the common law as something that is a descriptive claim, right? I disagree with Posner on how you should test that hypothesis. And the two main points of disagreement have to do that I do not really care about the outcomes of the norms, because that is conflating the content of the doctrine with the effectiveness of the doctrine, right? So if the doctrine has a certain goal but fails to deliver it, we have a reason to criticize the doctrine on its own terms. But this is something different from telling what the doctrine is, or what the doctrine is trying to achieve on its own terms. And the second is that in order to compare, to declare that you have a nice hypothesis, you should at least test it against an alternative, right? So what I do in part 4, in chapter 4, is to show how to do that. I'm seeing that my time is upping, so I will leave that for more for elaboration later. But the idea in a nutshell is that you can formulate statements in the form of, if the goal is total welfare, then when we talk about the harm to market participants, the legal system will talk like the judges and the legal system more generally will talk in these terms. If it is about consumer welfare, they will talk in these terms. When we talk about how we justify exceptions, in one case we will talk in one way, in the other case we will talk in another way. And then the problem that you have is that since courts are not in the business of providing us the materials to answering the questions that we have from a theoretical point of view, one of the things that you face is that one of the problems that you face is that often the reasoning of the court is superficial. So then you need to come up with a way to aggregate right sets of court decisions with higher and lower degree of theoretical depth. And the way, the position that I am willing to defend more extensively, if you want, is that we should really give more significance to the court decisions where the court decides to go deeper. And in parallel, we should give particular attention to the court decisions where the court carves out an exception from the previous understanding of a certain norm. Because in those cases, the court is disrespecting the expectations that people have developed on what the relevant legal standard is. So in those cases, it is definitely not cheap talk to refer to a certain goal as the goal that is particularly relevant. And I just have two slides that I wanted to briefly talk about. I have reached a point where I think the hypothesis is well justified in its context, but since its scope of application is antitrust and consumer law, and there is so much in between, there is all the sector-specific legislation, but there is also so much outside of this continuum, right? Because you have, for example, general contract law, and then you also have parts of tort law that also contributes to disciplining market behavior. It is really time to reach out and see how this hypothesis works in other contexts. One context to answer this question myself, but actually you should be the one answering this question. I believe that we can divide contracts along two axes, and the first is exchange versus organizational, and the other one has mainly to do with what we want to obtain with the contract, whether the creditor of the characteristic performance is in there for material gains or other types of gains. So an organizational contract for material purposes is a corporation, an organizational contract for non-material purposes is a family. going to the movies with your friends is an exchange contract for non-material purposes. Buying food at the supermarket is mainly for material purposes. Of course, there is all the in-betweens in the real world, as contract lawyers always know, that it's never so easy to draw these lines. But this hypothesis is meant to apply to exchange contracts. And I do not expect it to work elsewhere. But I would be very happy, I guess, to be proven wrong. But the purpose of this conceptual framework is to explain what are the normative elements that are characteristic of a market exchange. And I think, in conclusion, that what is characteristic of that kind of exchange is a commitment to consumer welfare, as I discussed before. And I am happy to say that I can develop more on why I think that this is a good normative standpoint, because I have been exploring it more recently, starting from research on reciprocity. And with a colleague and longtime friend, I am looking at this also in terms of game theory, and the results are very promising. So if I think I have spoken enough, and I have put enough on the table and left enough between curtains and promises of being able to elaborate more if needed, that I can give you back the floor, Simon.
Well, thank you so much, Fabrizio. It's a very, very thought-provoking and very, very exciting project that you've been working on, and really appreciate you sharing all of those with us. So right now, if you have any questions that you would like to ask Fabrizio, please raise your hand or drop your question in the chat box. I'm sure you must have a lot of questions I would like to ask, and also folks at Illinois in the classroom, feel free to also ask, and I think Zongjun would help us deliver the questions. So I might start with my kind of my understanding, and I so one thing is I really thought a lot about the difference between like total welfare and consumer welfare, and all of those. One of my research is about the personalization economy that we're facing, where algorithms function through gather people's data and then use algorithm to control people's behavior. That has always been a very, very on the right path until people got addicted to the service, hate speech being spread, and then people became miserable again. And right now in the United States, I would say most we're still struggling to understand how to kind of tackle this issue. And of course, there are a lot of policy instruments that you can look. I mean, there are a lot of theoretical frameworks, a lot of policy instruments that have been looking into law and political economy as a way to address this issue, looking into different regulations. So I would love to learn more about, like, in your definition, your methodology, how would you approach kind of this phenomenon that we're facing right now?
Okay, Sam. So I would like to first make a digression, because I think it's important, because I understand that many PhD students are in the audience, and for some of you, the job market is approaching, and so what I want to say is that personalization is a very dear topic to me, because it's the topic that helped me navigating through the postdoc phase of my career and eventually land a position, because price personalization in particular is where you see the current law and economics people to struggle the most in providing you an answer that vindicates the normative intuition that there is something fundamentally wrong in people using my evident passion for Ghostbusters against myself. If you look behind me and zoom in very careful, you would see several instances of that passion. And there is a clear theoretical connection between the research that I've been doing and this kind of issue, right? And working with Annalise Siboni, I have tried to flesh out these connections, starting from a very an intuition that many people share. Also, the European Consumer Association now shares that, namely that there is something fundamentally wrong in price personalization and we should prohibit it. This was the intuition. Actually, economic theory helps you to understand that even if you care about consumers, right? Even if your goal is to foster the interest of consumers as much as possible on the market, there are situations where predictably price personalization can benefit consumers. So then the drama becomes how to make sure that you can design an institutional framework that supports that, in comparison to an institutional framework that allows traders to use that to exploit consumers. And now that I am editing this volume with Mateusz Groszowski, which should be ready in the next 3 weeks, but I've been saying this for 6 weeks now, so I don't know. I realize that the ideological positions of the people that you engage make it so difficult for them to say, yes, if somebody's charged more because a trader has more data about them, this seems to me is fundamentally wrong. It is very difficult for people, and contingently I observe that it is particularly different for people with a low economics background. But if you look at these issues from the assumption that consumer welfare is what defines allocative efficiency, then you will be focused on making sure of 2 things. First, that price personalization can be used to foster competition at the margin, especially in context of quality differentiation. Second is that you can allow traders to offer targeted discounts so that they can increase access to the products to people that are not willing to pay the market price, but are willing to pay something that is still profitable for the trader. So if you are capable of making sure that price personalization works there, then it is going to be useful. But the struggle, for example, that I am having with people is that what I've been observing is that people that tend to think about these issues from a total welfare perspective, and this is ironical considering that we're talking about granular market practices, they refuse for some reason to take into consideration necessity of a certain market practice, which is something that competition lawyers know is something that you really need to take into consideration. And constitutional lawyers, because of proportionality analysis, know that it's something that you really need to take into consideration. So the trader should need to show under a necessity test, right, why Simon paying more than Fabrizio is necessary for Vanessa paying less than Fabrizio. Good luck with that. Because the fact that you can doesn't mean that it's necessary for you to do it. And the fact that you will make more profit by doing that doesn't mean that it's necessary for you to do it. This is really not what necessity is about. But people that tend to look at these issues with a strong law and economic spectrum, not everyone, right? If you read the book, when the book will be out, you will see that not everyone who has that kind of background has this issue. But, for example, the economists in the project did not have that issue. And this is very interesting, right? But we perceived more resistance to consider this argument that is actually essential to the idea of granularity that is behind this market practice. But your real question was, what is the best institutional framework? And the comparative part of the book tells us it really depends on the legal system you're operating with.
Right, right. I think Vanessa, that's a very very good response. Vanessa, I think you have a follow-up question on that.
Yeah, so thank you, Fabrizio, for this very interesting lecture that you gave us, explaining basically what we really don't know. So my question is actually related to the last part of your presentation. Because I don't remember exactly the slide, but it says something along the lines that this consumer welfare hypothesis would not work correctly or appropriately in contexts that are outside of exchanges that are considered of contractual nature. And I think that you broadly define what is a contract in this setting. And my question is connected to Simon's question, because I was thinking, would this hypothesis actually work in the environment of the digital space or digital platforms where actually there is not a contractual or enforceable contract, right? We enter into platforms, we sign these terms of use, which are not contracts. At least in the US, the privacy notice has not that status. So would that, does it mean that you are also excluding from the application or your hypothesis these type of exchanges, which are much more of a data nature, just so to speak? Thank you.
So Vanessa, thank you very much. No, I got lost into my own legal system. So my sin was universalizing my own legal system, and actually even my understanding of what my legal system looks like. Because to me, data per service is an exchange. Maybe it's not an exchange contract, but it's definitely an exchange. And actually, the deadly sin of price personalization is that I am giving you something that and in return for that, you are giving me less because you are using that to increase the price for me. So this is a very strange bundle, right? Normally, bundles and time should be more attractive for the person that is receiving them rather than less attractive. If they're less attractive, they should attract strong regulatory scrutiny. So that point is taken. So it's about exchanges, whether they're of contractual nature or not. So I've already expanded the hypothesis.
Perfect. Thank you.
All right, we still have around 10 minutes. Sue, you have your hands up.
Hi, Fabrizio. Thank you so much for spending time with us. So I was wondering what I mean, because in the US, like the antitrust law trend is actually to move away from the consumer welfare standard and criticize it for straying away from the core of antitrust law, which should be instead of like the consumer welfare, right? So I was wondering what you think. I was wondering what your response is to that, to this trend, and why you and why you think and why you think EU antitrust law should actually embrace the consumer welfare standard in in light of what the US is doing. Thanks.
Okay, so I will try to do this quick, but it's going to be difficult because you have stepped onto the wasp's nest, and you have not only stepped on it, you have jumped on it. Now, there are several layers to my answer to your question. The first layer is that in the US, contrary to Europe, the consumer welfare standard has turned into way more than in Europe, right? I'm not saying that Europe is the ideal world of antitrust litigation, but in the US, it is distinctively more difficult to win a case against the traders. Why? Because the consumer welfare standard has been turned into a set of very significant constraints. We have constraints also in Europe, and some of these constraints comes curiously from the economists that we use as consultants, right? So I am class rep in 2 class actions in Portugal, and I can tell you that I wanted to make a theory of harm that included, I wanted to invest to rely on a theory of harm that imposed also a privacy harm as a quality problem, and they were like, we can't really prove that. How are we going to prove that? We can't do that. Let's move on with a more an easier to prove theory of harm. And I said, okay, as long as we can change the market structure, that's fine. At the same time, so there is this institutional set of issues for which the US and consumer welfare standard, it's not the standard per se, it's the way in which it is institutionalized that is being criticized. And one interesting thing to look at is that among the proposals by the FCT, FTC, there are several ideas that would make US antitrust law look way more like European antitrust law, okay, at the institutional level. The other thing that is really concerning in the US is that the interest of workers is not being taken enough into consideration in mergers. And merger is a very strange field of antitrust law, because you have not an exchange. You're talking about dudes that should be competing with each other, and instead they decide to merge. Oversimplifying, yeah? I'm sure that competition lawyers' ears are bleeding right now. But it is an exceptional derogation to the dynamic of the market, the way in which companies relate to each other. And one of the things that this derogation can do is to increase monopsony power, right? The power of the employers, because instead of 2 employers competing with each other, now you have 1 single employer, right? And you may well say that for reasons that have nothing to do with the exchanges that then this company will do on the market with its own consumers, the fact that you have increased the concentration on the employer side of the labor market is a problem. But this is outside the scope of my hypothesis, in the sense that to me, that is not the one between capital and labor is not an exchange contract. Is part of the organizational contracts that make a corporation or a firm of any business organization work. So you can rightfully criticize the single-handed focus on antitrust law on consumer welfare without criticizing consumer welfare for the context for which it is meant to operate. And the idea why I think it makes sense to say consumer welfare is normatively attractive is because it represents an idea of reciprocity that is not the direct reciprocity between next week is my birthday, so you should give me a present, and then when it's your birthday, I will give you a present. It's not that kind of reciprocity. It's similar to the kind of reciprocity that animates me when I see an old person going on the train. And I helped that person because my grandparents lived in southern Italy and they had to visit me and they took the train. And as they grew older, there had always to be somebody that would help them with their luggages. So what I think is that just like somebody did it for my grandparents when they were still able of traveling, I am doing it now for somebody else. And this is exactly the normative fiber of the idea of consumer welfare. On the market for bananas, the banana producer accepts that it owes something to the consumers of bananas. And that same person goes into a clothes shop and he expects that the other person has accepted the same kind of duties towards him or her. And the same if this person goes out for a beer and so on and so forth. There is an idea of indirect reciprocity where essentially everyone accepts that they need to exercise maximum effort in performing the activities on which they have specialized, so that others can delegate those tasks to them. So it strongly connects with the Smithian idea of the market as a way to increase productivity, and also with the idea of self-interest. but it also connects with another Smithian idea. I invite you to search in the text that Simon circulated. I think I have the direct quotation from Adam Smith. If it is not there in the other paper on reciprocity, I surely have it. Adam Smith says the boldest thing ever about the interest of consumers on the market. He even says, the second sentence on that point is, this maxim is so self-evident that any attempt to prove it would be absurd. So what was self-evident at the end of the 18th century to him is not mainstream anymore in the 21st century. How about that? So this is the kind of issues that I have been trying to, that I have been struggling with. And my distinctive contribution to this approach is to say, look, economists think in two different ways, but I am a lawyer, right? What matters to me with regard to the economic theory that I am supposed to be using is the one that is most matches best with the legal system that I have. So between the US and Europe, I can say, oh, the US is at the normative level, right? US antitrust law at the normative level is committed to consumer welfare. And then on those grounds, I can criticize the S out of it, because at the institutional level, that is not true. Because burden of proofs are placed on the wrong actor, because sometimes claimants have to prove things that are almost impossible to prove, because damages that it is equitable and reasonable to assume that they exist, if they cannot be proven according to a certain degree of mathematical rigor, they don't exist. They do exist, even if you cannot prove it in that way. And that should be enough to give some level of compensation, but most fundamentally to prohibit that behavior in the future. Because the beautiful thing about prohibitions as a way to ensure market structure is that I do not need to prove exactly what the benefits are going to be, as long as I know that there will be some benefits. So if I get closer to the benchmark by introducing that prohibition, I should introduce it, all things equal. But the problem then is that things are not always equal, which is why then we need more research on the matter.
Well, Fabrizio, I think you have masterfully explained a very complex idea within a short amount of time. We have 1 minute left. If there is any questions, just feel free to drop it in the box. But again, very, very, very thankful that you are here to join us, and then to meet all of our other participants who are going to watch online, in which we're going to post this on the YouTube channel. But before we end our session, I'd like everyone to turn on their camera and we can take a picture for social media, if that's possible.
Can I say one thing, which is based on what you have already answered to me about law and political economy? You are not so sure it's a science, but you tend to believe that it is. But you are optimistic about its outlook. I would like to challenge you on that, because I think that there is too much cancel culture in that group of scholars. Because if you search on Twitter, I had a beautiful discussion with Ramsey Woodcock on that. Ramsey Woodcock is somebody you should invite, by the way. And Ramsey's point, which I completely made my own instantly, is that you need to win the battle for ideas in order to ensure long-lasting institutional change. And you will not win the battle for ideas if you let the other camp dominate the content of one expression that has become a buzzword, right? So if it is true that efficiency comes a long way in terms of getting a response from the regulator or from the judge or from the jury or the academic, then you should try to make it your own, not criticizing it on their own terms, but trying to change the terms of the discussion. And one way to do that is to show that for many economists, the interest of consumers is at the core of the economic process, and therefore it is central to the definition of allocative efficiency that we should be using.
Yeah. I would love to continue to discuss the discussion, but would you like to? We can take a picture first, and I would love to respond to that. But yeah, let's take a picture first. I'll announce like next semester's our next event. But 1, 2, 3. Yeah, and then our next event is going to be Professor Andrew Hayashi from Virginia School of Law. He's going to talk about network analysis, the small and diversifying network and legal scholarship, a study of co-authorship from 1980 to 2020. So I will looking forward to see you all next week. Thank you.